All rise. The Court of Appeals, Division 1, is now in session.
Good morning. Please be seated. This is the time set for oral argument in ANDRARMILLER Designs, LLC versus USBANK, our civil number 16-0723. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of the clock in that regard. We have read the briefs, we've reviewed the record, we've conferenced the case. We're pretty familiar, I believe, with the underlying facts and the issues that you've brought to us here today, so please keep that in mind as you make your arguments. We are recording the proceedings both by audio and video. The video will be available on YouTube in a matter of days. But because we are recording this, I'll ask that as counsel approaches the podium to make their arguments, that you identify yourself and your client for us. With that, appellant may proceed.
Thank you, Your Honor. Morning. May it please the Court, my name is Lauren Stein, appearing on behalf of the appellant, USBANK. There is no binding or governing authority in Arizona that supports the judgment that the trial court entered on the claims that were brought by Miller Designs. Miller Designs, the plaintiff, filed a lawsuit predicated solely on the affirmative use of the statute of limitations defense. It sought to declare that a foreclosure under USBANK's deed of trust was barred by the limitations period because the bank did not complete a foreclosure sale within 6 years after acceleration. The trial court entered a judgment that declared the bank's deed of trust unenforceable. That judgment was erroneous for separate and independent reasons. First, Miller Designs didn't have standing to assert in an affirmative manner the statute of limitations defense. Under settled Arizona law, a party to a contract or one in privity has standing to assert the personal privilege of the statute of limitations. Miller Designs
didn't. I thought Miller Designs actually had a possessor interest in the property, correct?
Miller Designs had an interest by virtue of its acquisition of the sheriff's deed, yes.
Okay, and under the statute, by taking that possessory interest under the statute, they have all the rights of title that anyone else would have as an owner of the property, correct?
They have the rights to the real property, and we know that by virtue of 12-1626. But there is a distinction between rights in the property and rights in contracts to which they are not a party. And Arizona law makes a distinction between certain rights that they've held are personal to parties to a contract or those in privity, and a distinction between other sorts of rights that are non-contract-based rights that other parties can invoke. And in this instance...
Well, except the statute says they have the rights as the judgment debtor would have. And that right would be the same as the judgment debtor being able to assert a statute of limitations defense, wouldn't it?
I disagree, Your Honor, because the statute says rights in the judgment thereto. And if I'll read it, acquires all right, title, and interest and claim of the judgment debtor thereto. Thereto meaning the rights in the real property. The statute doesn't say all rights, title, and interest of the judgment debtor in contracts relating to the property. This was a contract that was entered into many years before this particular party ever acquired an interest in the underlying real property.
But our cases have held that the person who takes possession of a sheriff's sale takes the same property interest as the interest of the previous borrower.
Yes, Your Honor, an interest in the property itself, but not an interest into a separate, what this court has held a personal contract right. And in fact, to conclude that 12-1626 gives a purchaser to sheriff's sale a right to separate and independent contracts related to the property would go against the decades-long law in Arizona, which says that the statute of limitations is a personal defense to a borrower or one in privity. Acquiring the property at a trustee's sale doesn't give a party a right, doesn't transmute the interest into a party to a contract or one in privity, doesn't create privity. Those are pretty distinct concepts under Arizona law, which isn't conferred by virtue of the statute.
Okay, so if we had a borrower who borrower loses their property in a sheriff's sale, but they buy the property in the sheriff's sale, do they have the right to assert a statute of limitations defense or no?
Yes, because they were a party to the loan documents. So they were a party to the loan documents, so they can raise any defenses to those because those are personal defenses that they can raise. In contrast that, because this particular entity had no relationship with the borrower, it had no relationship with the bank, and simply acquiring the property of the trustee sale didn't somehow confer those rights on that particular party. And we know that because Arizona law has developed decades-long case law which demonstrates that very clearly. One who can raise the statute of limitations defense is its personal defense that can be raised or waived by the borrower or one in privity. And to extend 16-26 to confer a right on a third-party purchaser would transmute that law or extend it to a place where Arizona hasn't gone yet. And now there's no authority directly on point, but I think we can point to the RCBT CIT case, which was issued by a different panel of this court, as persuasive authority for the argument. In that case, there was a third-party tax lien purchaser. And this court, a different panel of this court, held that the purchaser didn't have standing to raise in an affirmative manner, as a sword, not a shield, the statute of limitations defense to preclude enforcement of the deed of trust. This is a very similar instance to what you have here. You have a third-party stranger to the loan documents attempting to assert what this court has held for many decades as a personal defense available only to the parties to the document. To conclude that Miller Designs had standing under this circumstance would take Arizona law to a place that it hasn't been. And, Your Honors, if you have any further questions on the standing, I'm happy to answer them now or continue on with the revocation.
It's your time.
Thank you, Your Honor. The second independent reason why the trial court's judgment was erroneous is because the statute of limitations never ran. There's a 6-year statute of limitations to foreclose on a deed of trust after acceleration. In this instance, U.S. Bank revoked its acceleration of the deed of trust and thereby restarted the statute of limitations. U.S. Bank is squarely within the 6-year period. Now, this appears to be an issue of first impression for this court. Although a panel down in Division 2 has addressed this particular issue in the Wood case, no Arizona court appears to have yet addressed the issue of whether a lender can revoke its acceleration of a debt and under what circumstances. Now, courts around the country have addressed this issue, and an overwhelming majority of them have held, yes, a lender can revoke its acceleration of a debt and thereby reset the statute of limitations. Now, there's no dispute between the parties to this case that should be the rule here, that yes, a lender should in fact be permitted to revoke its acceleration and reset the statute of limitations. The disagreement here is the standard that should be applied. And we submit, Your Honor, that the standard the court should apply is one that is consistently applied across the country and adopted by the court in the Wood case. That the lender must simply manifest an affirmative intent to de-accelerate or revoke acceleration of the loan. That's consistent with what Division 2's panel held in the Wood case. It's also consistent with a number of courts across the country. And it makes sense, Your Honors, because it's effectively the flip side of what this court has held is sufficient to revoke to trigger acceleration of the debt. The court has held that something as simple as noticing a trustee sale is sufficient to accelerate the debt. We submit that canceling a trustee sale should also be sufficient manifestation by a lender to revoke acceleration of the debt.
Just simply canceling it?
Canceling and canceling the trustee's sale and reinstating the debt, which is what you have here, Your Honor. And if you look at the two notices of cancellation, what you have is language, which is pretty standard, which says we're rescinding, canceling, and withdrawing the trustee's sale notice. And it's the trustee's sale notice, Your Honors, which accelerated the debt.
Was there anything else that was given besides the acceleration, the notice of the trustee sale that would indicate to the borrower that the debt was being accelerated?
We have the two cancellation notices which were recorded, deemed constructive notice. We also have the right to cure notice, Your Honor.
But there was nothing independent of those. Those are the only three. That's the only three things in the record that would indicate that you were accelerating the debt.
Revoking acceleration of the debt.
Correct.
Yes, Your Honor. And so we've got three separate and independent acts, each of which, whether you look at them separately or collectively.
Maybe I didn't ask that correctly. Is there anything else that would indicate that you gave notice to the borrower that you were accelerating the debt?
The notice of the trustee sale.
That
Your
was
Honor.
the only thing.
In the record at this point, Your Honor.
Okay.
Which courts around the country have found is sufficient to accelerate the debt in the first instance.
And just so I'm clear, you think that by not moving forward with the trustee or removing that, what I'm wondering, is there any specific language that you need to include in a revocation of the notice of trustee sale to ensure that you've revoked the acceleration clause?
No, Your Honor, I don't think that there needs to be any magic language or any special language. It simply needs to be a manifestation that the trustee's sale, that the lender is no longer exercising its right to accelerate the loan and thereby sell it at a trustee's sale. I think we get into a problematic situation if we look for magic words or some special words that have to be required in the particular documents. And when you look at the way that the case law has developed across the country, a majority of the courts don't find that anything particular needs to be said. It simply needs to be a manifestation. And in this instance, when you look at recording a notice of trustee sale being sufficient to accelerate the debt, recording a cancellation of the notice of trustee sale, which also should also deaccelerate the debt. We go one step further here in our case because we do two things in the notice of trustee sale cancellation: rescind, cancel, withdraw. That's a quote. The notice of trustee sale, and reinstate all obligations under the deed of trust as if the notice of trustee sale had never been given.
And if that isn't required, why is it in there? And if it isn't in there, why shouldn't it be?
Well, Your Honor, I think it's simply abundance of caution to indicate to the borrower, we are rescinding the notice of trustee sale, we're canceling the sale, we're putting us back to square one, where you are still in default, because default and acceleration are two different events under the loan documents. You're still in default, but we've deaccelerated, we've removed our ability to accelerate and continue on with the sale. But, Your Honor, in terms of any specific language, I think we get into a troublesome situation by suggesting that any magic or specific language be included. Because you may have a circumstance where you've got a less sophisticated creditor who, by virtue of canceling a notice of trustee sale or not including magic language in that cancellation, clearly intends by its conduct and words to revoke its acceleration, but because it didn't use a specific phrase, is deemed not to.
But haven't the cases around the country specifically said that there has to be two things? One, there has to be a notice that it has been canceled to the borrower. If you just simply cancel, does that give notice to the borrower that you have revoked the acceleration clause?
Yes, and so I'll address your question in two parts. The courts around the country, I believe, have indicated that, well, and including the Wood case, simply what's required is an affirmative manifestation by the lender. No court that I'm aware of has held that a specific type of notice must be given to the borrower. Surely it must be an outward manifestation from the lender. But whether it needs to be constructive or actual or receipt-based notice, I don't think you need to reach that question, because surely in this instance, recording the cancellation notices with the county recorder is deemed knowledge to the world, is deemed knowledge to the borrower, and in this instance, actual knowledge to Miller Designs. Your Honors, I'll remind you, in the affidavit submitted in support of summary judgment, Miller Designs affirmatively researched the record. It was well aware of the deed of trust. It was well aware of the cancellation notices in this instance. So the party that is actually here before the court challenging the notice had actual notice. So in terms of, do you need to get to the question of what type of notice must be given, I don't think you need to get there in this case.
Well, hold on. But I thought the bank's position was that you had given sufficient notice because you had included this clause. That just wasn't just simply a cancellation of the sale, and we're just going to renotice it next week or next month or whatever. But we've actually taken the affirmative step of putting in the notice of cancellation that we have vacated the acceleration of the debt.
I think in this instance, yes, the cancellation notice, which includes language that makes clear that the sale is off and no longer accelerated, is helpful. I do think, though, Your Honor, that simply canceling the trustee's sale notice, which was the act of acceleration, would be sufficient. If noticing the trustee's sale under Arizona law is sufficient to notice up the acceleration, the flip side of it should be sufficient, canceling the sale, to revoke acceleration.
How does this all work into the statute of limitation that's contained in 12-548,
12.5.
which is the contract provision?
Yes, Your Honor. Thank you, Your Honor. Well, the statute of limitations, would run upon acceleration of the note. The note was first accelerated by recording the trustee sale notice.
But there was a default long before the notice of trustee sale.
There was
under
a
the contract.
In terms of the timeline, there was a default, and there was an initial trustee. There was a default in 2008. An initial trustee sale was noticed. The borrower then came current on the loan. That trustee sale notice was canceled.
When did he come current?
I believe it was in 2008, Your Honor.
Okay.
When I sit down for rebuttal, I can get that clear.
Well, let's assume that in 2008 there was a default and it's never been cured. Doesn't the statute of limitations for the contract start to run in 2008 under 12-548?
It would depend on whether the amounts were accelerated. It would run from 6 years from the acceleration, Your Honor. So if there was
What about the acceleration just simply accelerates the future payments, not the past payments?
Correct, Your Honor. So it would be a question of, I guess, which set of payments would that statute of limitations run on?
Well, that would be my question, is if the bank had waited 5 years, 10 months to file their trustee sale and then canceled and under your theory reset it, the statute of limitation only runs for future payments, not past payments, right?
No, I don't think I agree, Your Honor. And maybe I'm mistaking the hypothetical. Sorry.
No, you said you would have, if the first payment is defaulted in 2008, when does the statute of limitations start running on that first payment?
Immediately. Once there's a default, the statute runs. All future amounts would begin to run upon the acceleration.
Correct.
Which,
but for those payments that have been defaulted, when does the statute, you don't reset those payments, right?
No, I don't believe so, Your Honor. Your Honor, and let's also not forget the right to cure letter. I know I mentioned it very briefly, but the right to cure letter was also sent to the borrower in this case, and it also indicates that the borrower was in default and had the opportunity to cure. And if it didn't cure, there would be unaccelerated. The debt could be accelerated. So in sum and substance, Your Honor, 3 separate and independent acts, which I think whether you look at individually or collectively, revoked acceleration of the loan and reset the statute of limitations for purposes of enforcement of the debt. The trial court's conclusion otherwise, Your Honors, was erroneous. 2 more points before I sit down and reserve my time. I'm sorry, Your Honor, do you have a question?
No.
Okay. There is unrebutted evidence that amounts were advanced, additional amounts that are considered additional debt under Section 22 of the Deed of Trust, after April of 2010. Those amounts have never been accelerated. The statute of limitations continues to run on those amounts, and the bank continues to have the ability to collect those amounts. So
when did you raise that issue?
we raised that issue, Your Honor, in the motion for reconsideration, but this court can consider it based under the authorities that we have cited down below. We did have an opportunity to brief it. The trial court, though, declined to consider the issue, but I submit that you can, you do have the ability to consider it now. So part and parcel with that is the judgment itself, which declares the deed of trust unenforceable, was erroneous because we still have the ability to collect on those amounts that were advanced and haven't been accelerated after April of 2015. And moreover, simply concluding under the Provident case that the debt is no longer enforceable doesn't eliminate the debt or the lien on the property. And, Your Honors, I see I have little time left, so I'm going to reserve my remainder for rebuttal.
Thank you, Ms. Stein.
Thank you.
Ramos.
Good morning. Ari Ramras for the appellee Miller Designs. This is Miller Designs right here. Your Honor, this case, it really comes down to the case of the Goglia case, which has been cited, the Arizona case that was cited by both parties on appeal, which says that doubtful cases will be decided against waiver. That's this case to a T. It's a doubtful case where there's been an alleged deceleration, waiver of an acceleration, but it was anything but clear and unequivocal. And that's the standard that the cases use. That's the standard that both parties have agreed on appeal should be used. Was the waiver clear and unequivocal? And the answer is no. If we look at the 2 items that and you know, the reason why that's significant is, that's the standard of waiver, clear and unequivocal. And even the case that the bank has cited, the Boren case out of the Fifth Circuit, agrees that that's the framework where you have to consider this issue under traditional waiver principles. And so, is this a doubtful case? Yes. And going to the two items, three items, but it's really two items, the notice of cancellation and the right to cure notice. I'll just discuss both of those briefly. The right to cure notice, I'm actually surprised that counsel is still relying on that. And on oral argument below, we cited the transcript where the bank's attorney admitted that was an oops moment where they made a mistake in even sending that notice because the notice of sale, that there was already a notice of trustee sale. It was already accelerated. And so they mistakenly, admittedly, sent this right to cure notice saying, if you don't pay this amount, we may accelerate and we may notice a trustee sale. Well, they already did that. So that was a notice that was sent by mistake. It was confusing at best and certainly does not meet that threshold of clear and unequivocal waiver of acceleration. I think
Counsel, if I may, I
Yes.
have a couple of questions I'd like to ask you. Are you admitting that or agree with the proposition that once accelerated, a bank or a lender can revoke the acceleration?
I think it's not an issue that I don't think that this court has to reach. If you find,
but we might want to, and I
Okay.
want you to answer my question.
I think so, Your Honor. I think if we take it under waiver, it's a little bit unusual because you're waiving a right that's already been asserted and elected, but yet you're kind of saying never mind. But under the general principle that you can waive rights, we're assuming that you can do that.
So when you accelerate a debt, the lender can revoke the acceleration and put the parties back to square one.
I think so. If they do it in a way that's very clearly communicated to the borrower, and we cited and this is in preparing for the argument. We actually just recently found this recent 2017 New York case that came out. We cited the supplemental citation yesterday. We filed this Bernal case, and that goes to.
You have a citation?
Yes, it's 59 New York NYS 3rd 267. And this case goes a little more into detail of what does this notice to the borrower really need to say. And what the case says is it has to bring home to the borrower, even if it's called a notice of deceleration or waiver of acceleration, that may not be enough. It really has to bring home to the borrower, you can start making installment payments now, and we will accept them. And if it doesn't bring that home to the borrower, it's not clear enough. And that's what that case says. But so I addressed briefly the right to cure notice. I think the more serious argument that they're making is the cancellation of the notice of sale. They have never made the argument below or in the briefs that merely canceling the sale was sufficient. This is the first time today an argument where they've argued that even if we didn't include that additional language in the notice of cancellation, merely the fact that we noticed it would be sufficient. If you consider that
can you look at the language of the clause that was placed in the notice of cancellation and explain to me why that wasn't sufficient to give the borrower notice that the acceleration had been revoked?
Yes, Your Honor. So the reason why it wasn't sufficient is that the bank itself is relying on it. And, well, first of all, there's two reasons. Okay? One is what's in the language, and the second reason is how it was sent. So what's in that language is one issue. And what's really interesting is that this is a statutory form, which is very, very important to keep in mind. The notice of cancellation is a form that is actually in the statute of what it's supposed to say. And really all it's supposed to say is that the sale has been canceled. And then it has to have a legal description of the property. So what they did is they took that statutory form, and then at the end of a 2-page meets and bounds legal description, they tacked on this superfluous language that's not part of the statute form.
Okay, well, I'm still waiting for you to answer my question.
Yes,
What's in that clause that doesn't communicate to the borrower that the acceleration has been voided?
So what's not in it is the word acceleration is not in it, number one. The waiver is not in it. Waiver of acceleration is not in it. Actually, waiver is in it. I take that back. But it's on a part that they're not relying on. The biggest problem with that language is that they are citing it out of context and putting the part they don't like in a footnote. And the part they don't like says, because they have to be read together, it's in the same paragraph. The part they don't like, and this is the problem with the language, is that it says, this cancellation shall not in any manner be construed as waiving or affecting any breach or default, past, present, or future, under said deed of trust, or as impairing any right or remedy thereunder, but is and shall be deemed to be only an election without prejudice not to cause a sale to be made. Only an election without prejudice not to cause the sale to be made. So what they're telling to the borrower there is, all this is we're not having the sale right now. We're not selling it. We may sell it in a week from now, but we're not selling it now. And
well, except if this was a revocation of the acceleration, they could change their mind in a week and accelerate in a week, right?
Correct.
So the fact that it says we're waiving it just is at this time we're waiving it. And doesn't the last clause that says under said deed of trust, it does nor modify nor alter in any respect any of the terms, covenants, conditions, or obligations thereof, and said deed of trust and all obligations secured thereby are hereby reinstated and shall be said and remain in force the same as if said declaration and notice, which is the acceleration, had not been made and given.
And if it was just that language in isolation, I think they would have a stronger argument. But what the trial court found, and I think correctly, is that when you combine it with the other language, which you have to read it together in the same paragraph, it is ambiguous. It really is. And even using the word reinstatement is very confusing, because reinstatement is a term of art under the statute. Reinstatement is something that only the borrower can actually do by paying a certain reinstatement amount. That which we know wasn't done here in this particular case. And so
it says reinstated.
Right. But the reinstated, it cannot be reinstated under the deed of trust or the deed of trust statute unless there's a payment being made by the borrower. And so that's a very confusing term to use there if what you're intending to do is to waive an acceleration. It doesn't say that we're waiving the acceleration. It doesn't say you can start making installment payments and we'll accept them. And that's what the New York case says you really need to bring home if you're going to make this a clear waiver of acceleration.
Do you think that this clause gives anyone that would be searching this title pause on whether or not the acceleration had been revoked?
I think it would cause someone to be confused because it's ambiguous. I think another large problem here is that they're just recording the superfluous language. And, you know, this is a big problem because counsel says, well, it's the flip side of recording the notice of trustee sale, which is the acceleration. So the deceleration, which we should be able to record in a cancellation of the sale. But what that overlooks is the fact that the notice of trustee sale is not only recorded, but it's also posted, published, and mailed. And so the borrower is going to get it under normal circumstances. Whereas in this case, all they did was record it. And they cited a new statute for a statute for the first time in their reply brief, which is ARS 33818, making the argument that constructive notice should be sufficient.
Well, counsel, I think Ms. Stein told us that in the affidavit submitted below that your clients acknowledged they had carefully examined the record and were aware of this.
I will tell you my clients did some research. I don't know how extensive that record is below, but I think that's not the question here. The question is what knowledge did the borrower have, not my client. And so this is information that has to be brought home to the borrower. And so
I thought your argument was that once Miller Design had purchased the property in the sheriff's sale, that they stood in the stead of the borrower.
Yes, Your Honor. But
so if that's true, then isn't the notice to your client actual notice to the borrower?
No, Your Honor, because that happened much after the deed of trust became unenforceable. That kind of is conflating the standing issue to even be here today with the issue of what notice was communicated to the borrower when they canceled the trustee sale way back when, years ago.
But wouldn't it indicate that your client received notice or was on actual notice that there was a potential for a waiver of the acceleration?
Yes, and this is the point that I want to make, though, about constructive notice, is that who is it constructive notice to? Prospective purchasers, not to borrowers. So if you look at the Preston case, and this is 94 Arizona 214, 94 Arizona 214, it says the recording statutes are designed to give constructive notice only to those persons who are under a duty to search the record. These are creditors and subsequent purchasers, not existing borrowers. And so the borrower, the fact they know that a sale has been noticed, there's been an acceleration, they're not going to, unless they're going to the recorder's office periodically checking to see if a notice of cancellation has been recorded, they're never going to see that notice of cancellation, let alone that superfluous, ambiguous language that was tacked on to the end of that legal description. They're not going to see it. They're never going to see it. And what it really does is it brings home I think very telling is this Atlas case from Oklahoma that we cited. An individual cannot waive his rights by words spoken to himself, which no third person hears.
But the borrower in this case also got the letter, correct?
Yes.
Whether it was by mistake or otherwise.
Yes. So that was the right to cure notice, and let me address that. But I also want to just mention one more thing about the notice of cancellation, the fact that it was only recorded. The bank also argues in its reply brief that mailing it would have been an arbitrary requirement. But yet, if we look on page 17 of the bank's appendix, which is the deed of trust at paragraph 15, that's actually a requirement of in the bank's deed of trust to mail notices. So
was the borrower wasn't even in the property at this point in time?
They weren't in the property.
So mailing it to the property would have been...
It may have been ineffectual. Was there a forwarding address? I don't know. But does the constructive notice, the effect of the recording statutes that are only intended to affect subsequent purchasers, does that excuse them from complying with the notice requirement of the deed of trust itself? No. And so not only is it maybe a best practice to give notice, and the Boren case, again, the Fifth Circuit case that they cited acknowledges that not only is it maybe a best practice to mail notice, but it's actually required in the deed of trust. And the reason for that is that the borrower is not going to be periodically, realistically, going to the recorder's office every week or two and seeing, was there a notice of cancellation recorded? And if so, let me go past the two-page legal description and see if they tacked on any other language that I should be aware of. And even if they read it, they're going to see something that's very ambiguous, that says that the bank's not waiving any rights and that they're just causing the sale not to be held. It doesn't say they're waiving the acceleration. It just doesn't. And so they did receive, or it was mailed to them, the right to cure notice. But again, that notice was mistakenly sent, and again, confusing at best. I want to address briefly the standing argument. Counsel is really confusing two things. One is privity of contract, the other privity of estate. And so when you're talking about an action on a promissory note, for example, that might be a good argument. There was no privity of contract. But in this case, what we have is we're not talking about an action on a promissory note. We're talking about the issue of, is there an encumbrance or a lien against my client's house that can be enforced? And because of privity of estate, because of the statute that you mentioned, my client does have privity of estate, and they are in privity with the borrower in that sense. And so, I mean, what is this all about? What's the bigger picture here? If we look at Arizona law, it says you have to have a direct stake in the outcome to have standing. That's really what's required here, a direct stake. Could there be any more of a direct stake when someone is threatening to foreclose on your house to say that, wait a minute, this lien is unenforceable? Of course there's standing to do that. And there's actually Texas cases directly on point that we've cited, the Goswami case and the Long case. The Ordeorn case that the bank repeatedly refers to actually recognizes that people other than the borrower and those of privity actually have been held to have standing in certain circumstances, including lien creditors. And even including, in that case, it was extended to be a general creditor. Normally a general creditor, unlike a lien creditor, wouldn't have a direct stake. But in that case, it was a receivership proceeding where the receiver wasn't asserting it. So the Ordeorn case said, okay, you can assert it as well, even though you're not in privity. We know with lien creditors, which my client was before it actually became the owner of the house, lien creditors all the time have lien validity and priority disputes with other lien creditors. I mean, I've been doing that for 20 years. That's routine. Of course, there's standing to do that. The RCBT Holdings case, I'm not sure why counsel is mentioning that this morning. That's an unpublished case that their firm was involved in. There were 4 independent bases for that court's holding. This privity issue was, I think, dicta. Didn't fully discuss whether the lien creditor in that case, not the owner, the lien creditor should have standing or not. It involved a tax lien holder. The taxes and insurance argument, very briefly, Your Honor. This is a case where the trial court declined to consider it. That's an abuse of discretion standard. I'm not really sure why counsel is, for the first time in their reply brief, they've cited this line of cases starting with Provident Mutual, which is a 1914 case. As recognized in the Wood versus Fitzsimmons case, that case was superseded by statute in 1941 when ARS 12-1104 was enacted. And in any event, we're not seeking a quiet title here, which is what that case was about. This is a declaratory judgment action. Do you have any other questions?
Thank you, counsel.
Thank you.
Yes, Ms. Stein.
Thank you, Your Honors. Ambiguity. You heard counsel say several times that the deed of trust, the cancellation notices were ambiguous, and you saw that as well in the trial court judgment ruling. If there was ambiguity on summary judgment, there shouldn't have been summary judgment. This case should be remanded for a trial. I submit, however, Your Honors, that there's nothing ambiguous about the cancellation notices. The sole piece or the sole provision that you've been pointed to is the provision in the cancellation notice which refers to the fact that the default is maintained. Default is a very clear different event from acceleration under the terms of the loan documents. Indeed, it's set out in a completely different section. Your Honors, there is no ambiguity. The cancellation notices in and of themselves were sufficient to revoke the acceleration. Next, Your Honor, you heard argument regarding the standard. What standard should be applied? Should it be constructive notice? Should it be actual notice? You don't need to reach that question, Your Honors, in this case, because there was actual knowledge in this instance. And Plaintiff's Summary Judgment Exhibit 13, Your Honors, is the declaration of Bill Miller. Mr. Miller is the principal of the plaintiff. He's a lawyer in town. And he said in his declaration, I was aware that the house was in foreclosure, but after reviewing various recorded documents affecting title to the house, concluded that the bank's lien appeared to be time-barred. Your Honor, he indicated in the record below that he reviewed the title, Your Honor, and I think you can conclude he had actual knowledge of the title with respect to this particular piece of property. So there is no dispute that there was actual knowledge. Nevertheless, Your Honors, constructive knowledge, if that's what you want to say is required, was given here. What the bank did is completely consistent with the recording statutes in Arizona, and to hold that recording a document is not sufficient goes against Title 33 and the case law that's developed that demonstrates the type of notice that creditors and others must give to borrowers in order to proceed with foreclosures. Next, Your Honor, the deed of trust doesn't require that the cancellation notice be mailed to the borrower. I think that's in provision 15 of the deed of trust. And finally, Your Honors, I do want to return back, Judge McMurdy, to a question that you had asked me about the statute of limitations. You had asked me about when the statute first began to run. Yes, in 2008 upon the default, and then the accelerated or the future amounts that weren't yet due would have been, the statute of limitation would have run upon acceleration of those amounts. But once it was de-accelerated, once the notice of cancellations was recorded, the statute of limitations for those amounts was reset. I just wanted to make
For the accelerated amounts?
For the accelerated amounts, yes, Your Honor.
Right. So
I just wanted to make sure I answered your question.
that was my question, is for the amounts from the date of default in 2008, whenever that may be, through they continue to run. I mean, that under the statute that I cited you, and you agree with that. It's only the accelerated amounts that we're disputing.
Well, no, Your Honor. The initial amounts in 2008, the statute would have begun to run then. They then accelerated the amounts with the trustee's sale notice and then reset everybody based on that. So I think it's that period in the middle that perhaps we're
Okay.
going across each other on. Right. And I see my time is up. If Your Honors have no further questions for me, I'll sit down.
No, thank you, counsel.
Thank
we
you.
thank you both for your arguments and the briefing in this matter. We're going to take this under advisement. We'll issue a written decision in due course. We're going to take a brief recess to allow counsel for the next argument to come forward and get set up. Thank you.